Already along with me is Reddy Neumann, my business partner. We bring every week immigration updates, especially on business immigration. Emily, what do we have today to discuss?
Well, we want to talk about where Biden is right now, how he's been doing on immigration, what kind of report card would we give him based on the actions he's taken for employment-based immigration. Where do we stand with immigration reform through the reconciliation? That is the Build Back Better Act, now that the Infrastructure Act has passed both houses. We're seeing a lot of reports of where the main applicant is receiving their employment-based green card and getting their approval, but their spouse is still pending. What do you do in that situation? And also, as travel opens back up, we now have the COVID travel bans lifted for those who are vaccinated. We also have upcoming the Dropbox eligibility expansion is supposed to expire at the end of the year on December 31st. That's where you are eligible for Dropbox if you had that visa within the last 4 years rather than just 1 year. Will that be extended beyond December 31st? We're going to talk about all of those things and, of course, answer your questions.
With regards to the Biden administration, Emily, there are some good things that I would say that Biden administration is definitely in favor of the immigrants. They're not anti-immigrants like the previous administration is. But when it comes to the actions that they're taking, though, they're not as in line as what they promised when they came to power, though. They said they are supposed to smoothen the immigration process. There are a lot of steps that they still need to do to undo some of the things what Trump administration has done. They have undone some of the things. For example, they have taken the financial documents information. They've undone some of the things, but not. What they can do is they can have, like the old system before Trump administration, exempt all the employment based from the adjustment of status interview. They can take off the they can give an employment authorization for 4 years instead of 2 years. They can expedite the process of the EAD. They can expedite the 485, put more people in there, because why are they adjudicating the EADs, advance paroles, every now and then? And why can't they just give the green card for the people whose priority dates are current? They wasted 65,000 green cards, though. Although they did very good improvement in the last quarter, though, the first 3 quarters, they were very lacking behind. They tried to cover in the last quarter. They did not as much as required. But in this year, they have 290,000 green cards. I am hoping that if they continue at the same pace of what they did in the last quarter of 2021, that means from August to October of 2021. If they continue at that pace, though, they can utilize the entire 290,000. But still, they need to improve very much on the appointments at the consulates. They should be able to do the remote appointments. Dropbox appointments are still not available plenty. So I would give a B- to them. Their intention is very good, but their actions are not there. I have seen in the Bush administration, Emily, when President Bush said that the processing time had to be cut down, they didn't cut down. He just fired all the district directors. And that's what this guy needs to do, file out the people who are inefficient. Which are the service centers that are lacking behind? For example, Texas is lacking behind. Fire the service center director. What are you doing? What's the purpose why you're there? So if you can do the drastic steps, you can automatically improve. So he still needs to do a lot better. What do you say?
Yeah, I agree. I think that one of the best things was eliminating the memo that got rid of deference. So we're seeing much faster adjudications on a lot of petitions for extensions, or L1 extensions, H1B extensions, and the like. So that is progress. But we're still not seeing enough progress on H4 adjudications, the L2 adjudications, the H4 and L2 EAD applications. Why do those need to take so long to be approved? 7 to 14 months it takes to get a simple EAD, when the only thing that you have to prove is that you're married to an H1B or L1 holder. It should not require anything beyond that. So definitely need some progress on processing times. Customer service at USCIS is a mess. It is so hard to talk to a live person, and once you do, they can't answer your question, or they tell you they're going to refer you to a tier 2 officer and they'll call you back in 2 weeks.
Really?
And then you might not be there at the phone when they do actually call you back, and so you got to start the process all over again. There's no InfoPass appointments available, and the consulate's lack of appointments, that is a big cause for concern when we're lifting all of these travel related bans. The consulates have to step up and start processing these applications.
Emily, now the infrastructure bill has passed. It has passed through the Congress and the House, both houses of the Congress. It's becoming law right now. Anything in there for immigrants?
No, nothing at all.
So now, what's the difference between the infrastructure bill and Build Back Better Act, though? What's the difference between this and that?
So the Build Back Better is really Biden's agenda for the budget. So the infrastructure was separate. Now we're dealing with the budget, which is the reconciliation that we've talked about before. This is how we're going to spend our money for the next 10 years. And in that budget, that's where there were hopes of real immigration reform happening, because reconciliation only requires a simple majority from both the House and the Senate. We don't have to worry about the filibuster. Well, so the House is making good on their promises for employment-based. They've included the recapture of unused green cards. They've included the provision where if your I-140 has been approved for 2 years, so your priority date is at least 2 years old.
They changed it actually.
Yeah.
If the priority date is 2 years old,
then you're eligible for adjustment of status, even if there's not a green card available to you. It does not take off the 7% cap. It does not remove the spouses and children from the cap either. So that's on the House side. But on the Senate side, we're still stuck with this parliamentarian. We're on to Plan C. Who knows? Supposedly they've been presented.
So what's a Plan C on the Senate side, Emily?
So on the Senate side, they are looking at providing basically TPS, protected status for undocumented immigrants. So they get work authorization and deportation relief for a total of 10 years, because this budget lasts for 10 years. What, immigration advocates wanted was a path to citizenship, which is not there. This is our third attempt. I don't see how it's any different than the first 2 attempts.
Ignore the parliamentarian who has not been elected. She's not part of the Constitution. She's not part of anything. That's the advice. Don't hide behind the parliamentarian. We did not vote for her. You appointed her. You can take her off. So there's no reason for the Democrats to hide it. What's the purpose? Why, when you have a majority in the House, when you have the majority in the Senate, you have the president, you can't do it. What are you going to do it at a later time? What's the purpose why you're in the power? So don't, these Democrats are trying to hide behind the parliamentarian. They should ignore her and just pass the legislation. Look what Mitch McConnell did when he was the majority leader. He wants to get his Supreme Court nominees. He got it. He didn't budge to all these things. There are a lot of other things that he did. Why can't Chuck Schumer do the same thing what Mitch McConnell did? So definitely Democrats need to improve on this one to get the budget reconciliation bill, and they should include the immigration provisions. Even though I may not be very happy with the provisions that are there in the Congress, House budget reconciliation on the immigration part of it, because I would ideally like to not include the family members. I would ideally would like to take the 7% per country limited, but I'm still okay with the House bill. If that bill can be mirrored in the Senate bill, then we'll be in a good shape. We should ignore the Senate, we should ignore the parliamentarian, just polish. We have the 50 votes there, we have the full majority in the House, so that's all enough for us to get it. The Vice President vote is already in our favor, so we should be able to get it. Ignore the parliamentarian.
And if we don't get it, we need the president to step up and start issuing executive orders.
So can he,
right away.
What are the things, assuming, Emily, that we are in January and the election year comes in January and the House representatives and senators are hesitant to pass at that point of time because they're, in some of the places the primary starts shooting at about March or so. So what can the president do if the Congress doesn't act?
Well, I think he can provide EADs to people that aren't currently eligible for EAD, so based on an approved I-140, for example.
That's good.
I think that mean, the way that the statute is written, I don't think spouses and children were meant to be counted in the employment-based. He could change the interpretation to be in line with how the statute is actually written and
just
remove.
like the way H-1BCs, the 65,000 doesn't
Exactly.
include the H-4s. So if that's there, what you're telling is definitely that'll be a great relief. Instead of 140,000 green cards, we're going to have 280,000 green cards. Even if the can he take out the per country limit out by himself, Emily?
I don't think he can. I think Congress has
To do it, yeah. So if he can not count the family members, for the people whose I-140 is there, he can issue the employment authorization for him and the spouses. The spouses are already there. And these are the steps that can be easily achieved by the administration. And we should try to focus on, at this point of time, we should channel our energy to have the Congress passed. And if it doesn't get passed in the next 2 months, then we will draft letters for you guys to approach the administration to issue EADs for the I-140s and also file the 485 application for family members not to be counted. Now, at this point of time, the pressure should still be on the House and senators. We have drafted a letter for you guys to send it. If you have not already sent it, go at the bottom of the video. There's a link that we have provided. Please write letters to the congressmen and senators. Have all your friends write letters to the congressmen, and please have your voice heard by your senators and congressmen. All
right, another strange issue we're seeing pop up recently is when the main applicant's green card is getting approved, the spouse's is not always getting approved at the same time. So you have one family member who's a green card holder and the spouse who maybe was on a dependent visa like an H4 or L2, well, now they're no longer in H4 or L2. How do you travel in that situation, especially if the spouse doesn't have the advanced parole? You can't get an H4 or an L2 visa. What are the options in that situation?
And especially the prior date is backlog, though. If they are maintaining the non-immigrant visa status, Emily, for example, if they are an H-1B, not an H-4, because if the main applicant got the green card, H-4 is gone. So they will be considered to be married to the adjustment of status, though. If they are maintaining the non-immigrant status, I strongly advise them to file a green card 485 application under the Family 2A, which is current for them. Because when the dates go back, we never know when the dates are going to come back. We don't want to count on it. So I would have them file a 485 application under the Family 2A. Now, that's easier. File an I-130, 485 application, EAD and advance parole. They'll be in a much better shape. If by any chance they are not maintaining the non-immigrant status, either they have used the EAD of the adjustment of status, or if they are in H4, they can't. I mean, H4 is gone. Then I would suggest them to still file an I-130 application in the consular processing so that they can go to their home country and get the green card there while this is getting processed. So this is like an insurance that you're buying on. Just in case if the priority date doesn't move forward, you will get it through your spouse in a different family category. And at the same time, this number will be counted towards the family, not the employment base, which is exactly I would like to have it. So definitely people need to consult lawyers, need to take steps. If you have received, the main applicant has received and the derivatives have not received, there are creative ways of getting them the green card instead of waiting for a long period of time.
All right, we talked earlier about Dropbox options, and as of right now, it's expanded until the end of the year, so that if you've
Can you explain what is a Dropbox, Emily?
Right, so this is basically interview waiver of the visa stamping process. So rather than when you're applying for your visa stamp, instead of going in for an in-person interview, you drop off your passport and all of the supporting documents and they issue the stamp without interviewing you in person. So these are meant for people where there's a very low risk to the United States. So people who've already been in a certain visa category before, they had the visa issued after a certain time period on the machine readable passport. They're applying again in the same category. They've never lost their passport. They don't have any kind of security clearance issues. So originally this was if your visa had expired within the last year, you may be eligible. Then they expanded it to 2 years so more people could use that option and not have to go for the in-person interview during COVID. And then they expanded it to 4 years, which is where we are right now. But that expansion to 4 years goes away December 31st as of now. Do you think that that will be extended beyond December 31st so more people can use Dropbox?
Well, I would ideally would like them to expand to the 4 years as it is right now, until the next 2 years at least, until the COVID is gone. But we have to see how the administration is going to do it. I want all the people, if they can get the appointments, if they are in that 4-year limit, try to get the appointments as soon as possible in December, and that's very tough. What people are doing is they're going online, refreshing, and when something comes up, they're making an appointment. If they don't do it though, there will be a lot more applicants going for the interview. It's going to have a lot more backlog also for the consulates, and that's going to affect the effectiveness of the consulates. It's going to delay the people who are eligible for visa to get it. So definitely it is in the best interest of the administration to expand this one for the same 4-year period, just like the way what it is right now, Emily. Let's go to the questions. People are asking, "Hi, my senator is a Republican. Does it matter if I send a letter?" It does matter. Even if it's a Republican, their stance might be not as hard. They may not fight as hard as possible. So irrespective of, you should voice. I mean, it's not just the anti-immigrants that can voice to them. It's also you should also voice to them and explain, this is exactly the trouble I'm having. They should know it, and whether or not you are able to influence that person, whether he's able to change it or not, but it still is worth for you to write a letter to the congressman and inform him that which side he should be taking on.
Ron from YouTube says, "I have an initial perm in EB2 that's valid until next month. I used that perm for EB3 and that I-140 is approved. Now I want to file the I-140 in EB2. Does the 6-month validity for perm still apply if I'm filing an EB2 now?" No, it does not. So even after your perm has expired, that 6-month validity from the day it's approved, you can file a second I-140 petition using the expired perm because you've already submitted the first I-140 timely. So you can do that after the perm expires, no problem at all.
Rajiv is asking question, "Hey, should I go for EB2, EB3? You told before EB3, EB2. Now, Rajiv, here is what's going to happen with the EB2 and EB3 line. Though a lot of lawyers are projecting that EB2 is going to go forward, EB3 is, there are a lot of projections out there. Here is what's going to actually happen. Sometimes the EB2 will be forward, sometimes the EB3 will be forward. It will keep switching for the next 4 or 5 years. If the things remain as it is, nothing changes, EB2 and EB3 will keep switching. The best option, if you have not filed a 485 application, is to have both EB2 and EB3 I-140 approved and keep it ready. In that way, whichever comes in, you can jump onto that boat. There are a lot of advantages to have both the things available though, instead of having only one available. If your employer can do both, that's better to have both the things available. Now you can use the same labor certification. If the labor certification is for EB2 and EB3, you can file it.
Punkage says, "Is email copy of an H4 approval extension sufficient to travel outside the US and go for a visa interview instead of the original hard copy approval because I never received it?" 2 things. For an H4, you don't actually need the H4 approval from USCIS to go for visa stamping. You need the H-1B spouse's approval to go for H4 visa stamping, just like when the H4 first got the visa to come into the US. If they were outside the US at the time you got the H-1B, you never filed anything with USCIS. So they're eligible for the H-4 simply because you have an H-1B approval. So that's fine. And also the consulates don't require original approvals anymore because everything is in the PIM system. So generally they do accept copies of 797 approvals.
Rahul Jain has this question. "My son is on the verge of aging out. I-140 downgrade pending and the dates have now retrogressed. When he gets his EAD due to AOS pending, can he use the EAD? No, I would suggest that he should not use the EAD application. Also, I don't understand how he's going to age out when the downgrade is still pending though. Here is the reason, Rahul Jain, that amount of period of time that the I-140 is pending will be deducted from his age. Since his I-140 is continuously to be pending, it's not approved yet though. He's not aging. His age is not getting out. You may want to watch a video where I put it on CSPA in our YouTube. We have that CSPA Reddy Neumann PC. You can look into that video that gives a clear direction. Or you may even want to consult a lawyer to have a better strategy so that you can have a good path for your son. Is it going to be moving out of H4 is one of the options that you may have to seriously consider that.
Will the filing dates be accepted for the December visa bulletin? What are our thoughts on that?
Good question.
I would say historically within the recent history, they have been accepted, especially where we saw date movement in the month of October. They continued to accept those filings into December and even into January. With the dates really not moving, I don't see why they wouldn't accept those filing dates, but we have to unfortunately wait and see until we get that announcement from USCIS.
Kundana has this question: can we leave USA immediately and get a green card with 2-year re-entry permit and use 4-year 1-day rule to apply for citizenship? Oh my goodness, you got all this one and then now you want to move back to India? I would recommend strongly that you contact a lawyer though. It's not that you use the 4-year and 1-day rule. There are a lot of other steps that you need to be worried about. You need to keep filing the income tax returns. You have to maintain the residence in United States. These are all the absolute requirement for you to maintain the green card though. It's not that you just apply for the re-entry permit, you just leave for a period of 2 years. Not automatically will be eligible for citizenship. It is better that you take care of rest of the stuff too before you leave the country.
Nikki asks, does USCIS cancel the EAD and AP card when a child ages out if the final action date is not current? Good question. We're going to see a lot of issues with aging out kids with these the EB3 date retrogressing. So the good news is no, they don't automatically cancel anything. So that if you filed the 485 hoping that your child's age would be locked in and the age did not actually lock in, the 485 will continue to process. The EAD remains valid. The AP remains valid. You may need to talk to a lawyer before you file a renewal of an EAD or AP for a child who's already aged out to determine whether it might call that issue up for the office, or they realize it, then they could deny the 485 at that point. But nothing automatically happens on the day they age out. Everything continues to process.
What is the timeline for H4 to F1? 7 months to 14 months is a timeline for H4 to F1. Pratibha has this question: how many days do I have to wait to switch the employer once I receive the green card? You can do it immediately. 1 day is good enough. There are rumors that you have to stay there for 6 months, but I don't know where those rumors are flying around. They have no truth in it. The USCIS memo clearly allows, and the AC-21 law clearly allows you to even switch the employer before you even get the green card. So practically, once you get the green card, though, you can do whatever you want. You can be a Microsoft CEO, you can flip a burger in McDonald's, you can be a lawyer like me, or you can just sit at home and do nothing.
Prashant says the BBB plan has a deadline for November 15th. Do you think this bill will pass in both chambers of Congress, and will the immigration provisions be kept? So I believe that deadline has now been extended, at least in the House, to December 3rd, based on a recent resolution. Will it pass in both chambers? I think a reconciliation bill will pass in both chambers, and then they will decide whether they need to conference to come to a consensus on the difference between the two bills. The bigger question is, will it include immigration, and if so, what provisions? I do think we have a decent chance of the employment-based provisions being included in both bills in the House and the Senate. I think it's the other types of reform for undocumented that are going to have a harder time getting passed in the Senate.
if we have a 485 receipt notice, but the priority date is not correct on it, is that a problem? No. We notice that a very significant amount of the time, the priority date is not properly reflected on the 485 receipt notice.
Sanjay has an interesting point. By asking people to file both in the EB2 and the EB3 category, aren't you just asking people to pile up the requests and increase the backlog? To an extent, when obviously you're doubling the number of petitions that USCIS has to process, but at the same time, we have to advocate for all the options that are available to people, and there's no restriction of only choosing one. So I think our point of view is it's better to have multiple options and go with whichever one happens to be the fastest. Because ultimately there is only going to be one green card approved, so they're not adding to the backlog of people waiting to get their green cards. You're just adding additional processing time to I-140 petitions, which do have premium processing available.
A couple of other extension comments on that. What you said, Emily, is that we are also contributing more money to the USCIS, that they can increase their resources, because it's not a free application that we are filing. People are spending $1,225 for each of those. They're spending thousands of dollars on filing this application. That increases the resource of the USCIS. And also, when we advise the clients, though, we have to advise to the best of what it could for particularly for them. We are not the advocates of the society. We are advocates of the people who are our clients. They are more valuable for us. So we definitely will advise clients that will benefit them the most. And also, if I was at one point of time a client of an immigration lawyer, I've gone through the process though. So I would look into what is best for this particular gentleman. If I were him, what should he do? If I believe that he should file, if I should file if I were him, then I would advise him to file again.
Rupika says, can I travel to India if my H-1B is expiring in 6 months and my company is planning to file for extension? Potentially. So number one, it depends on, do you have a valid visa stamp that's also expiring in 6 months? In that situation, you could go and come back, and then once you're back, file the extension, so that you don't have any mismatch between I-94 numbers by traveling while that extension is pending. So that would be one way to go about it. Or if you don't have a valid visa stamp, you may be better off filing the extension first, so that you can go for stamping for the fuller time period while you're outside the US. The main thing is, when you're outside the US, you can't request an extension of status. So you need to be in the US on the day of filing in order for the company to file it as an extension request.
Ryan has this question. Do you expect the EB3 to backlog if 150,000 family visas goes back to the family queue? Whoa, that's going to be dangerous. If that happens, definitely we may expect EB2 and EB3, both of them backlogged. Very, very, very seriously. OM has this question. I have both I-140 approved under EB2 and EB3, filed 485 under EB3. What is the best course of action? About 2 weeks ago, we presented on refiling or interfiling when the EB2 advances forward. I want you to watch that. There are some advantages in refiling the entire application. There are some disadvantages on it. I want you to watch the video that we did 2 weeks ago.
How long is USCIS taking to send the biometrics notice after filing these days? Service Center is MSC. I would say right now about 6 weeks to get the biometrics after filing. That's based on applications that we filed towards the end of September. We're getting those biometrics appointments now.
Yeah, but the ones that we filed in October, Emily, they're taking a long time to issue the receipt notices as compared to the September.
Yeah, definitely. These are cases where we recently got the receipts as well. Just within the last week, we started getting the biometrics. Meenakshi says, is it allowed or legal to work on a second job using a part-time H-1B for 20 hours with another employer? Yes, you can do that as long as that other employer files a concurrent H-1B petition, and they do need to specify the number of hours you will work. So if it will be part-time, the LCA requires an hourly wage, and then you list the number of hours on the H-1B petition.
Do I qualify for automatic revalidation? H-1B extension approved, previous H-1B stamp expired in June 2021, same employer filed an I-140. Yeah, if you have a 797 with the I-94, if you're traveling to Mexico or to Canada and you're coming back within 30 days and you're not going for stamping, you are eligible for automatic revalidation.
Raghu has a perm that was filed in March of 2021, and DOL's processing cases in June of 2021. The attorney is saying to wait until December for the next update. Does this mean my application has been picked for an audit? It doesn't automatically mean it's picked for an audit. We do see these processing times vary, even though DOL says they process first in, first out. There's some variation in that. So from time to time, we see applications taking longer than the posted processing time, and then they eventually get approved without audit.
Vijay Illa from YouTube has this question. I heard the rumor that we don't have to file the EADs for the H4s and L2s. Is that they're automatically renewed? Is that correct? The rumor with regards to the L2 EAD most probably will end up to be the correct one, though. We are expecting, USCIS has not announced any policy yet on it, but we got a credible information that they will come up with no more L2 EADs. If you have an L2 approval, you practically have an EAD. That is where we got very reliable information, though. But when it comes to the H4 EAD, that is not true. You still need to have the EAD applied. The reason why L2s are different, because for L2s, they don't need to have their spouse I-140 approval. So all L2s are eligible, spouses are eligible for the employment authorization, irrespective of whether the I-140 has been filed or not. But H4s, it's not automatic. They need to have the I-140 approved. So it is definitely, you will not be eligible for the, you will not be eligible just because you have the H4. You still need to, we still will have the old process for the H4s.
Satej from Facebook asked, do I qualify for automatic visa revalidation? I have a current H-1B extension approved with an I-797 and I-94. Previous H-1B stamp expired in June. Same employer and approved I-140. So automatic revalidation allows you to travel to Canada or Mexico only for less than 30 days. And yes, you can use your expired visa stamp and your valid I-797 approval notice with the I-94 to return without going for visa stamping. Now, if you apply for the visa stamp while you're in Canada or Mexico, you do not get the option of automatic visa revalidation. And it's only if your trip is less than 30 days.
Bhavesh has the I-140 prior to date of 2013. His new employer is filing, can the new employer file Eb2? What is the recommendation, Eb2 or Eb3? Bhavesh, for when it comes to the PERM labor certification, though, it's preferable to always be on Eb2. The reason is that if your PERM application is an Eb2, you can use the same one to file Eb2 or Eb3. You can do either of those things. Definitely, if you have in 2013, though, I mean, you should definitely do under Eb2, and if by any chance Eb3 goes forward, you can file an I-140 under Eb3, and then whatever date comes in, you can take that date to file the 485 application.
K. Reddy has an issue. His 485 was filed with a missing page last year and wants to know what are the chances of getting an RFE versus getting a denial of that 485. The EAD and AP have already been approved, but it's scared to use them because the 485 was filed without a missing page or with a missing page. So generally, if USCIS has issued a receipt notice for that application, it means they've accepted it as a proper filing. and they don't usually deny due to a missing page. Instead, they send an RFE asking you to send in that missing page. What usually happens when there's a missing page is they flat out reject the application and send it back. So I'm assuming if you got the EAD and AP approved, that means you did get the 485 receipt. So I think you're generally in good shape and should expect an RFE for that missing page.
Sometimes what happens is that, Emily, when you scan the hundreds of pages, one of the page it doesn't scan, and the people get scared about that too.
Right. Yeah, it's possible that there wasn't a missing page.
It's possible there wasn't a mistake at all. But if I were you, though, I would use the EAD and advanced parole if you want to use it, though, for the purpose of the 5th page missing. Since it's already accepted, though, yeah, I'm going to use the EAD and advanced parole.
Jay says, my I-140 was filed in July, and when I asked my employer for the receipt number, they say they didn't receive it yet. Is there another way to get the receipt notice number? It is unusual that it was filed in July and still doesn't have a receipt number, so I would first ask the employer if the filing fee check has been cashed, because if it has, that means the application was properly filed and you just didn't get the receipt notice. On the back of the cashed check, sometimes the receipt number will be there. The other option is for the employer to call customer service or the attorney and ask them to provide the receipt number over the phone as long as the check was cashed.
Another simple tip: go file the FOIA USCIS. You'll get that in 3 weeks. That's a hacking thing. You can do it. It's FOIA USCIS. Google it. File an online application. You'll get it.
Sad that you can get a FOIA in faster than you can get a receipt notice.
Right. That's very surprising, Emily. A lot of people have taken my advice and they've got all the information of the 485, especially the medicals that they filed. The medical was opened. I've seen a lot of those freedom of information, and they have all the information there of 693 form also. So yeah, FOIA, please use FOIA, guys. That's more faster. By the time you get a receipt notice, you might get a FOIA information. That's a very good thing what you suggested, Emily. Sohail Hamid asked this question: 485 rejection and denial are same? No, they're not. Rejection means no officer has looked into it. They have not taken the fees. Denial means it is based on the merits of the application. As Emily was discussing on the 5th page thing, it's already accepted. So once it's accepted, the filing fees has been taken. They are going to go to the file and deny it. But before they deny it, though, they will issue an RFE. I mean, I have never seen a straight denial of the 485 yet. Once they have taken the application, though, rejection can happen without any notice. They don't take the money, and it can be summarily rejected for some check is missing, or probably one of the page of the 485 is missing. They can reject it.
Suresh has a perm that was filed in the 5th year of H-1B waiting for the approval and wants to know, does the H-1B 7th year extension eligibility come with perm approval or perm filing date? Max out date is May 2022. So it depends on the status of the perm at the time you're filing that 7th year extension. The most important thing is, before you would have reached your 6th year limit, if your perm is still pending, has it been pending for 365 days or more? If yes, you can file a 7th year extension. Or if your perm has been approved and your I-140 is still pending, you're also eligible for the 7th year extension, just getting the 1 year, if 365 days has passed since the filing of the perm. So it's the filing date of the perm that's relevant for calculating the 365 days you need to qualify for the 7th year extension.
If you have an EAD, Venkat from YouTube has this question: if an amendment required? I'm working remotely from home, but my client has changed. I'm going for the stamping. I would recommend, if you're going for stamping, if the client has changed, I would recommend strongly to have an amendment filed. Even though technically it's not required, when you're going stamping, the consulate officers get very confused. They don't understand it that much.
Manoj wants to know, what's the current processing time for an H-1B regular case? I would say anywhere from 2 to 6 months, depending on service center and whether there's a request for evidence. In general, they're pretty quick.
Naveen has this interesting question. Can I file another 485 application in the same category? Because the USCIS is not following either receipt date or the priority date. What do you answer him?
I mean, you can if you have continued to maintain your non-immigrant status, but should you? I don't know.
I don't know. But to answer though, is it legal to file it? Yeah. I mean, these stupid guys don't follow the receipt notice or the priority date. Yeah. It's definitely not illegal to file 485 application. Second time.
Naveen asks, does cross-chargeability for a green card need to be specified to the USCIS officers, or is the officer aware of cross-chargeability? We do always put a bright colored paper everywhere, like throughout the petition, big bold letters, cross-chargeability. This is how they qualify, because if you've got to get it past the mailroom, the person opening the mail is going to look at your country of birth and your priority date and say the priority date's not current. They're going to reject it flat out. So it doesn't even get to an officer. So we have to get it so that the mailroom can see that this person actually qualifies based on a different country of birth. Therefore, the priority date is current. And then once they accept it, then the officers are aware of it.
I heard that H4 EAD extension will be the same as adjustment of status EAD extension, where people can work up to 180 days because of the court litigation. Himanshu Patra from YouTube. Reddy Neumann PC is part of this H4 EAD delay litigation, L2 EAD litigation. We are not at liberty to discuss very much, but we are, Stephen Brown from our office is the litigation head. He will probably update us more details, probably by end of this week, what's going on the litigation. And where the status of the H4 EAD litigation is. He will update us. He probably will update us on Friday, probably by next week. We'll update you, because we're not at liberty, because Reddy Neumann PC is also the law firm that sued the USCIS in the class action suit.
Shiva says, my prevailing wage request was submitted in March and now it's November. It's still pending. My employer says that the labor test becomes invalid and needs to be performed again, but my 6-year limit expires May 2022. Yes, so there are very specific time frames based on when you started the advertisement process and when the prevailing wage is issued. And so if they've already started the ads and the prevailing wage is still pending, it's possible the ads will expire. They're only valid for about a 6-month window, and they may need to do some, if not all of those again, and while they're waiting for the prevailing wage to be issued.
Suhail Ahmed, 485 got rejected because the prior date is not current. He used the cross-country chargeability. Can he resubmit the 485? Absolutely, you should resubmit the 485. No doubt, they did a mistake. You should, if you're eligible from the cross-country chargeability, for the people who are not aware what a cross-country chargeability is, either Suhail is born like maybe in UAE and he's an Indian citizen from the beginning. For the purpose of the green card, he will be considered as a UAE citizen. Or it could be that his spouse may be from born in a different country other than India, and he can use, even though he's the main applicant, he can use his wife's country of birth. That's called cross-country chargeability though. Yes, you need to, but one thing, Suhail, that you need to be careful is the 485 forms have changed on October 13th. So if you have used the old forms, now you're sending the same forms back again, they're going to reject it. Now this time, not because of the cross-country chargeability, because your forms are older. They are not the version. So make sure that the forms are updated before you file the 485 application.
Cash has a family-based I-130 approved and an Eb2 I-140 approved with a 2019 priority date, and wants to know, what does it mean for me if the BBB passes with the immigration language in it?
Ooh.
So assuming it's the House language that includes the recapture provision, as well as the provision that says if your priority date is 2 years old, you can file the adjustment of status even if a green card's not available for you. It means you would be eligible for adjustment of status based on that second provision because your priority date would be 2 years old at that point.
Yeah, he may have a lot of different, the recapture, he may not even go into that too. The priority dates might actually move all the way. But if by any chance priority dates don't move, you can pay that extra $1,500 and still file the 485 application. And you will not be counted towards employment-based immigration numbers at all under the House rules. Questions with regards to how long it's taking for the H4 standalone EAD. It's taking H4 EAD. It's taking around 5 months to 9 months right now, standalone EAD. For the people who have the EAD on the adjustment of status, we strongly recommend that you file within the 180 days. Don't wait until you go very close to the expiration of the EAD and file it. Try to file as early as you possibly can to avail the 6 months that you have under the adjustment of status EAD. So don't wait until a lot of people, oh, my priority date is current, I'm going to get the green card, and why do I need to file an EAD extension? No, do file the EADs as early as possible. Anyway, the filing fees is free. Do file the advance parole also as early as possible.
Susanta from Facebook has a perm that was filed a month ago, and H-1B visa will expire in December. His wife is also on H-1B and wants to know what are the steps to get the 7th year extension after the I-140. So since you have a couple of options, but since your wife has her own H-1B, that means you're eligible for H-4. So if you're maxing out in December, you can file a change of status to H-4. And then once you have your I-140 approved, you can file a change of status back to H-1B. That change of status does not have to go through the lottery because you've already been counted. And so it can be filed anytime as soon as you get that I-140 approved. Another option would be to go outside the U.S. to get the H-4 visa stamped and come back in, or stay outside the U.S. Once your I-140 is approved, your employer can file a consular processing H-1B petition for 3 years, get that approved, go for the visa stamping, and then come in back in H-1B status.
P.I. Gupta, I raised a service request to expedite the 485 last month, priority 10/2012. While the priority date was current, now I received a denial on the expedited request. Will it have a negative impact on my 485 application? No, it will not have any negative impact on your 485 application. V. Lakshmi 2, I have applied for I-131 for my son, got only for 1 year validity. Is it common? The rule was changed recently. That the I-131 and EAD should be given for a period of 2 years only, though. Is that only for EAD or advance parole too, Emily? That's my question.
Well, it's a combo card.
Combo cards.
Yeah.
So I don't know why you applied I-131 separately, though. So they should still have given for 2 years. It's not common nowadays, at least. About 6 months ago, 9 months ago, it was very common to have 1 year. But nowadays, it's not common. We don't see that often at all. 1 year extensions. It's always 2 years that we see I-131s.
Manoj says, if my spouse uses the Gcead, can I still file a second 485 and EB2 with me as the primary and her as the derivative? I filed the EB3 in October 2020. So technically you could, assuming that you have continued to maintain your non-immigrant status, but your wife would not be eligible to file a second 485 because she's no longer in a non-immigrant status because she's used that Gcead. So effectively, unless your wife is okay with you getting the green card without her, basically you can't file a second one.
I got my H-1B approved with ex-employer. How long do I have to wait to transfer to a new employer for a full-time? Immediately. I mean, there is no period of time that you have to wait. You can have next day, you can move to a different job. Absolutely not a problem.
Sachin applied for the 485 last month and then am getting married next month. He wants to know, can I add my spouse on the 485 so we can both get the green card together? So you can only add your spouse if your priority date is still current, whether it's under the final action date or the filing date. If it's the filing date, it's only if that filing date is current and USCIS says you can use that filing date. But assuming, yes, your date is still current, then and she can get into the US, I don't know where she is, but if she's in the US in a non-immigrant status, then she files her own 485 application with a copy of your I-140 approval notice and your 485 receipt, asking them to connect her application with yours.
Is the 5K green card still in play, Srikar? Yes, you're right. I wouldn't say it's 5K because they changed the fees a little bit here and there. They twisted the fees a couple of times in their modifications. But yeah, in essence, Srikar, what you want to achieve is to file a 485 if your priority date has been established by 2 years. Yes, it is still there. It's not 5K, it's a little bit, I can't read it out exactly because I have to add all the numbers. Yes, it's still in there. Either you may have to pay 4K or 6K, that's what I'm a bit confused on it, but yeah, it's still in play, and I know that you won't care if it's a 4K or 6K.
Nil has a downgrade I-140 pending and regular processing. The employer is not allowing premium. EAD and AP are approved. Is it safe to use that EAD with the I-140 being pending? And if the EB2 final date becomes current next month, can I do a concurrent filing? So, number one, it's risky to use the EAD before your I-140 gets approved. So you would want to be very confident that your I-140 is a strong case and has all likelihood of getting approved before you make that switch to the EAD. It's definitely much safer to wait for the I-140 approval. So that's one of the top reasons why 485s get denied in employment-based is if the I-140 gets denied. But if you do use that EAD and then you want to file a second 485, you won't be able to do that because you have to be maintaining non-immigrant status to file another 485 application.
Narendra Reddy has asked this question. This 5K green card, is it only going to get us the EAD or it's going to get the green card? Good question, Narendra. The answer is it's green card, not EAD. The people who pay this money, whose priority date has been established by more than 2 years, if they are willing to pay that money, they are exempt from the numbers. So they don't count towards the employment-based numbers at all. So you will be getting the green card, not just the EAD.
Bhushan has filed a downgrade in November 2020. Still no EAD or AP yet. Raised a service request. No luck. What do you suggest? I would recommend contacting Stephen Brown in our office regarding litigation as a possible option for the EAD AP delay. We are filing those lawsuits now for these interim benefits. It doesn't necessarily get you the green card faster because it's very difficult to use litigation to get a 485 approved faster, but it does can work for the EAD and AP. So Stephen Brown would be the person to contact in our office for that.
With regards to the $5,000 fees, it is $5,000. I confirm it. It's page number 912. Yes, it still is 5,000, but this is just in addition to some of the fees that we have to pay though. Another thing, as I confirmed before, is that you are going to get the green card. It clearly says that you will be eligible, you will be waived from the numerical limitations of the 140,000 green cards. This is in page number 912 subsection C I. That's the language in the law. So it is the green cards, correct? I confirm it. It's still there in this bill. It's still there. The 5K green card is still there. But we still need to get this one in the Senate. That's going to be a $1 million question, whether these provisions, what I'm showing you, will they come up in the Senate bill? That's more thing. House seems to be fine. This seems to be drafted by Joe Lofgren. That's the only person that I can think about. She is the Immigration Subcommittee, Judiciary Committee Chairman, and she definitely understands the business immigration much better than most of the other congressmen. She was an immigration lawyer fighting for the immigrants before she became an immigrant. She became a congressman, and she drafted this.
Sunil has his first 3-year term of L1B expiring in December, filed for an extension in the first week of October, but still no receipt notice. Is it normal to see a delay in getting the receipt? I've not really experienced that much delay in I-129 receipt notice issuance, so I would definitely be checking with the employer if the filing fee check has been cashed. That would suggest that the case is in progress and everything's fine. It's just the mailing of the receipt, something went wrong there. If the filing fee checks have not been cashed yet, you still have time. It's possible it was rejected, and as long as you refile before it expires in December, you're fine on that.
Nikki Sharma has this question. My daughter is born in UK. Can she get the green card even if my priority date is not current? Unfortunately not. If she is dependent on your green card, she's derivatory beneficiary though. It will be only yours when it's current for you, she will get it. Unlike the spouses where cross-country chargeability is allowed, where if your spouse would have been born in some other country, the cross-country chargeability allowed. The cross-country chargeability does not work if your children are born in a different country.
Let's see. Maki says, my H-1B extension was approved, but the spouse's H-4 is still pending. Can I book a visa appointment for all of us using my H-1? Yes, you can. No issues with that. What happens if the H-4 gets approved before we go to the interview? No problem at all. You still go for the appointment based on the H-1 approval. You don't need the H-4 approval once you're outside the U.S.
What's the use of discussing the 5K green card scenario when they're not adjudicating the cases for the 2010? Well, at least, you're able to file the 485 application right now. It may take a little bit time for them to catch up because of the number of applications that were filed in October of 2020, but the scenario won't be like this forever. We definitely would like to have this provision of 5K green cards passed. I mean, it's going to benefit a lot of people. It's going to exempt them from the numbers. So it's definitely is going to be very good provision. And these provisions are only for the next 10 years. So after that, the provision sunsets. Can I have 2 EAD applications, one on EB2 and one on EB3? Yes, you can. Now, the question is if you want to use the EAD, definitely at that point of time, I would recommend that you consult a lawyer so that you can choose which one you want to use it, which one you want to forego. Because the EB2 and EB3, the way I am expecting though, it'll be same as when you go to Los Angeles, the highways that are there, they have 16 lines in there, and one line moves forward, one line doesn't move, one line, it's going to be the same thing. Especially a lot of people who filed under EB3 are also eligible for EB2. A lot of people who filed under EB2 are also, all the people who filed on EB2 are also eligible under EB3. So it's going to be very zigzag. I mean, one time one will move, one time another will move.
Tilak wants to know, how are the approvals for the Gcead, EAD, and AP from the Texas Service Center? Filed July 2021. Biometrics were done November 1st. Not great. I think their normal processing time is still anywhere from 10 to 12 months. So they're still working on applications that were filed last October, and yours wasn't filed until July. Now, we do see some of the later filed applications are getting them faster. So that I don't mean to say that there's no way you're going to get yours in the next year, but they're definitely not great. We're seeing still lots of delays from those that filed last year.
Go ahead.
Tushardri says, can I go into India via Mexico and come back without the visa being stamped? Good question, but no. So automatic visa revalidation only allows you to travel from Mexico back to the U.S. or into Canada and back into the U.S. If you go from Mexico or Canada to India to come back into the U.S., you do need a valid visa stamp.
My daughter is 21 years. Can she file a green card for me? Yeah, yes, absolutely. If your daughter is born in United States and she is 21 years, she can file the green cards. A lot of people get confused, is it 18 years or 21 years? It is 21 years, not 18 years. They can file the green card application.
All right, well, I think we are out of time for today. Thanks so much for joining us. We'll be back next week as usual. Make sure to follow us on our social media. We're on Twitter and Facebook, on obviously on YouTube, as well as TikTok and Instagram.
Thank you.